welcome all of you. We will continue with the part 2 of environmental acts and laws. In the previous lecture, we studied what is the need for the laws, what is the definition of act, policies, procedures, rules, regulations, and what is the role of Ministry of Environment, Forestry and Climate Change, and then we explored some relevant acts related to the environment. The last act that we studied was NGT Act, the National Green Tribunal Act. So, in today's lecture, we will look into more detail about the structure and composition of National Green Tribunal, what are its roles and powers, and then followed by a couple of case studies related to the NGT. And to end with, we will look at a simple comparison or like how NGT works in collaboration or in cooperation with Ministry of Environment, Forest and Climate Change as well as Supreme Court. So, National Green Tribunal, for your information, India is the third country globally after Australia and New Zealand and first amongst the developing nations to have a specialized environmental tribunal or court like a National Green Tribunal. So, it shows how committed India is towards its environmental protection. This was established on 18th October 1910 under the NGT Act of 2010. So, this tribunal or court is responsible for effective and expedited disposal of cases related to environmental protection, conservation of forest and enforcement of legal rights relating to the environment. The headquarters is in Delhi and 4 regional benches are in Bhopal, Pune, Kolkata and Chennai. Since we have covered this earlier, I will go to the next slide. The structure of National Green Tribunal. So, it has like 3 layers of members, like it has one chairperson, then judicial members and expert members. So, the chairperson of the NGT must be a retired Supreme Court judge or a Chief Justice of a High Court. So, that is the mandatory requirement because NGT is also like a court, and if you look at the level wise, it is almost equivalent to or higher than the regular High Court. So, a Chief Justice of High Court or a retired Supreme Court judge can only be the chairperson of NGT. Judicial members can be the current or former High Court judges, not the Chief Justice, but judges of different High Courts. Expert members will be persons with professional qualifications in science, engineering, forestry, environment or related fields with minimum 15 years of experience, because that is very important to have expert members in the NGT, because Supreme Court it is a generic body. It's even though it is the highest level judiciary body in India, it is generic, it has to cater to different types of cases, almost all types of cases. But for environmental related cases, it is important to have an expert committee which have that experience or expertise in the environment related field. And the tenure of the NGT team is 5 years and there is a provision of no reappointment. So, every time this entire team is fresh and composed of new people, new members. Minimum 10 members should be there in the NGT and maximum 20 full time judicial members or expert members can be there. So, if you look at the powers and jurisdiction of NGT, it has its own original jurisdiction, it can appellate powers and execution authority over environmental matters, and it typically covers the violations under 7 different types of acts. One is Water Act, Water Cess Act, Forest Act, Air Act, Environment Protection Act, Public Liability Insurance Act and Biological Diversity Act. So, most of the acts with the name itself it is conveying what does it relate to, but Public Liability Insurance Act we did not talk about it earlier. It is related to the matters where people or society is affected by hazardous substances or accidents related to some industries. So, in that case all the community or employee people inside or outside the industry who are affected by the emissions or hazardous waste or substances coming from that particular industry, they should be getting proper liability insurance. So, that is covered under this act. So, all these acts are covered by NGT under its jurisdiction. So, it basically follows the principle of natural justice and not a typical civil procedure court, because since it is a court related to the environment and environment or ecosystem provides or carries out lots of functions and provides lots of services which can be economized. Okay. So, it is kind of platform to provide justice for those ecosystems and components of environment which are providing lots of services to society. Let us take a first case study about the ban on diesel vehicles in Delhi region. Okay. So, NGT bans diesel vehicles that was the final verdict. The case was for Delhi NCR region. All of us are aware about high pollution levels in Delhi, and which peaks up in the months of October end or November, when there is a crop cutting season, crop harvesting season, and because of this stubble burning. But then there are many more causes in Delhi itself, like lots of construction activities are going on, lots of transportation is there, industries are there, which pollutes the air, and there is high PM 2.5 and PM 10 particulate matter, NOx or NO2 emissions from vehicles, and they were identified as a major contributor. So, the case was filed by a local citizen or a lawyer, Mr. Vardhaman Kaushik and others, versus Union Government of India and others before NGT Delhi bench in 2015. So, petitioner was Vardhaman Kaushik, a lawyer, and some local citizens along with him, some local NGOs. And the respondent was Government of India, the governing body of Delhi, state governments around NCR, Central Pollution Control Board, transport and police authorities. That is why it says others, okay, to sum up all the respondents and all the petitioners. So, when this matter was brought in front of NGT, they observed that there are really higher levels of particulate matter all over Delhi, and the existing rules, just the checking of PUC, that is pollution under control checks for the cars or like vehicles, and odd even trial which was started by the government then, they were insufficient. And even after having these PUC checks and odd even number system, the levels of particulate matter and NOx did not go down. So, since these were the observations, the orders were passed. In April 2015, the order was to ban diesel vehicles which are 10 years or older than that, and to ban petrol vehicles which are 15 years or older than that. And the impact of this order or direction was to target high emission vehicles, okay, because it is a fact, like as the vehicle gets older, the performance or of the engine or the fuel efficiency goes down, and there is a chance of having higher emissions from the older vehicles compared to the newer vehicles. And when it comes to diesel, because of more particulates in diesel and more maintenance required for diesel vehicles, the life was 5 years less than that of petrol vehicles for banning them. But in December 2015, the NGT, the court, directed all the RTOs not to renew registrations of 10-year-old diesel vehicles. So, the purpose was having a legal enforcement mechanism, so that if RTOs do not renew the registration of older vehicles, they are automatically going to be scrapped in some time. In July 2016, so initially these two bans were only for the city of Delhi, but after 6 months this ban was extended to NCR region, the national capital region, like which covers Faridabad, I think Gurgaon, Noida. So, all these regions around Delhi, the ban was extended, and the impact of this ban was to control the regional air quality. And in 2018, like 2 years after this order, NGT ordered Delhi government to implement the vehicle scrapping policy, and the impact of this policy was to encourage the recycling of vehicle rather than dumping it somewhere or carrying it for long time and polluting the environment more and more. And people started considering adoption of EV, electric vehicles, and you can see all over India there has been a huge peak after 2018 for electric vehicles. So, this was a first case study where you saw how a matter was brought in front of NGT by a local citizen with a group of people and NGO, and it was against the government policies, or the objective was to propose some measures which government of India should take around Delhi region to reduce the air pollution, and NGT did listen to that and implemented and executed the orders, and now the result is the air quality has improved to a certain extent. The vehicles have been started to get scrapped after 10 years or 15 years of lifetime. The fake or like false PUCs have been stopped. There has been more scrutiny now. RTOs are not extending or renewing the 10-year-old diesel or 15-year-old petrol vehicles. And in fact, you can see the manufacturers have also stopped producing diesel based vehicles. Many companies have stopped manufacturing diesel vehicles and they are going for petrol based vehicles. So, case study 2 is about Tawang 2 hydro project. This case was against the Ministry of Environment and Forest because it was in before 2014, it is called MOEF. It was renamed as MOEFCC in 2014. So, what happened? Ministry had granted environmental clearance to this hydropower project, which was of 1200 megawatt in Arunachal Pradesh, Tawang 2 region, and there was a local federation, Save Mon Region Federation SMRF, which challenged this environment clearance. And NGT, when the matter was brought to them, they observed that there was lack of cumulative impact assessment for multiple hydropower projects in that basin. There were deficiencies in public consultation, especially with the local Monpa community, the people who lives there in the nearby vicinity where this hydropower project was supposed to be implemented. And then there were concerns for biodiversity and endangered species, because in Northeast India there are so many species which are not available or which do not exist in other parts of the country or the world. So, there were concerns for biodiversity and some endangered species. So, with these observations, NGT actually suspended the environmental clearance granted by the ministry, and it directed the ministry to re-examine the clearance process in 2013. So, see, even though MOEF is the apex administrative body when it comes to environment, but it is a ministry, and like if you remember in the constitution there were 3 branches of government like legislative, executive and judiciary. So, there is a possibility that some faults or errors may be made by legislative or executive branches, and in that case there is always a judiciary to come into the matter and resolve it. So, same thing happened here. NGT, even though the clearance was granted by the ministry, when it observed that there are some missing points, there are some deficiencies, there are some concerns which were not addressed before the clearance was issued, they suspended the clearance granted by ministry and they asked to re-examine the clearance process. So, the ministry's expert appraisal committee was instructed to revisit for the clearance in 2014 to 16, and when this ministry's expert appraisal committee went to the site, they did some more calculations, predictions, and they went to NGT again, but this time NGT again found that some particular type of species like the black necked crane, that habitat were not adequately considered and they rejected the environmental clearance one more time. So, the reason found was absence of proper wildlife clearance under the Wildlife Act, because NGT when it makes any decision, there are 7 acts which comes under the jurisdiction of NGT. So, whenever any case comes to them and if they see any observation is related to one of those 7 acts, they would check whether the proper clearance is obtained or not, or it is addressed or not. So, in this case the wildlife clearance was not there and they quashed the environmental clearance again for the second time. So, it ordered, okay, NGT, the job is not just to like squash or accept in the cases, many times it recommends or suggests a better alternatives, or it gives directions which can be followed by the petitioner or the respondent to make their case better. So, it ordered MOEF to work with Wildlife Institute of India and NBWL, it is National Board for Wildlife assessments before reconsidering the clearance. So, because these are the wildlife institutes and boards in India which are very closely associated with Wildlife Protection Act, and if they come into the picture and do some assessments for the ministry and then help them getting the clearance for hydropower project, it would strengthen their case. So, after these 2 case studies, these are some examples where NGT directed government to act on river pollution 6 plan within a month. These are some recent ones from 2025 only. For Yamuna floodplains, it had demarcated 17 UP districts areas. Then for having UV technology in sewage treatment, NGT had directed IIT Delhi to look into it and see whether it is effective or not. So, these kind of orders can be given by the NGT, and petitioner can be anyone, a local citizen, an institute, an organization, NGO or a company, and it can be against anyone in the country, that is also allowed. So, to look at the connection between these 3, National Green Tribunal, Ministry of Environment, Forest and Climate Change, and Supreme Court. Let us see what exactly these three mean and how they are connected to each other. So, ministry is it's a nodal ministry for the tribunal, and it is this ministry which provides administrative and financial support to the NGT, like funding, infrastructure appointments. So, all these are given by ministry. But NGT is a judicial body which enforce the laws framed by the ministry and other agencies. This is how they are connected to each other. Ministry, it is a nodal ministry for tribunal, and it provides administrative and financial support to the tribunal. Tribunal is a judicial body which enforces laws framed by the ministry and other agencies, but it does not mean that it will always approve the projects or the cases coming for or against MOEFCC. It often reviews or stays projects approved by MOEFCC if found environmentally unsound. So, it is possible that some projects can be approved or some projects can be stayed or reviewed again on the recommendation of NGT, even though it is approved by the ministry. So, this was the relation between NGT and ministry. And when it comes to Supreme Court is the highest judicial authority in India. So, NGT has no right to challenge decision of Supreme Court, but NGT's decisions can be reviewed by the Supreme Court. Okay. So, NGT is a subordinate judicial body and its decisions can be reviewed by the Supreme Court, but Supreme Court's decision, even though it is related to the environmental matter, won't be reviewed by the NGT. So, that is the connection between NGT, MOEFCC and Supreme Court. Last slide, we will have some cases where you can see the NGT orders were reviewed or were upheld or removed by Supreme Court. So, the first case, it was related to the first case study about 10-year-old diesel vehicles ban with the Vardhaman Kaushik versus Union of India case. So, after NGT gave the order to stop to ban the vehicles, when the government went to Supreme Court, the Supreme Court actually upheld NGT's order in 2016 and also extended it to NCR. So, it did not change it, it accepted NGT's order and said it has to be followed. In fact, it extended it to NCR region from Delhi. There is a case on solid waste management by Almitra Patel versus Union of India in 2016, and when these directions were given by NGT, the Supreme Court in fact continued with the same order and referred that guidelines or directions as a guiding framework in later municipal cases. So, it not only continued or accepted NGT's order, but once it implemented it, any more cases related to municipal or waste management came to Supreme Court, this directions on solid waste management were referred as a guiding tool, guiding framework. There was another case against Art of Living Foundation related to Yamuna floodplain. There was some big cultural event organized on the banks of Yamuna with millions of people attending that event, and MGT had imposed 5 crore fine on the organization for damaging or for shaking the ecosystem there. So, Supreme Court upheld NGT's powers to impose penalties. The organization did not accept NGT fine and it went to Supreme Court, but Supreme Court rejected the appeal and they said NGT's powers, NGT's penalties and fines were correct, and the organization was made to pay that much fine. The last case was of Sterlite Copper Vedanta case of 2018, where NGT allowed the reopening plant with some conditions. The Sterlite Copper plant was stopped for some reason and NGT allowed to reopen it, but when the case went to Supreme Court overturned the decision of NGT and citing it the state power. So, when state government approached Supreme Court against NGT's order of reopening the plant, Supreme Court overturned the NGT's order and say that the state is within its power to request for closing or not opening that plant, and the decision of NGT was overturned by Supreme Court. So, these are some of the cases where you can see NGT's orders may be accepted by Supreme Court or may be rejected by Supreme Court depending on the case to case basis, but most of the time, most of the orders it will be upheld or it will be accepted because NGT does have a proper framework and panel which keeps on changing every 5 years. So, it is always fresh with expert members involved in it. So, Supreme Court will have some confidence in their judgment most of the time. So, this is for today's lecture. To summarize, we started with the National Green Tribunal, its structure, its powers, jurisdictions, benches, what are its roles and how does it operate along with Supreme Court and MoEFCC. Then we studied two case studies. First one was on the diesel vehicle ban in Delhi NCR region, and second one was a hydropower project in Arunachal Pradesh. And finally, we saw how NGT can work aligning with the goals of ministry as well as Supreme Court. So, MoEFCC, even though it is a funding body or a administrative body for NGT, NGT can reject the clearances given by the ministry to different projects if those projects are not environmentally sound. Similarly, if NGT approves or gives some orders which is challenged by the respondent or petitioner in the Supreme Court, and Supreme Court found that okay, some fundamental rights are not being addressed or it needs to be changed or reviewed, they may accept or reject the order of NGT. So, with this we will stop here. Thank you so much.